नमस्कार दोस्तों। उद्धव ठाकरे बनाम एकनाथ शिंदे विवाद में 6 अगस्त 2026 को माननीय सुप्रीम कोर्ट में एक बेहद महत्वपूर्ण सुनवाई हुई। उद्धव गुट की तरफ से दिग्गज वरिष्ठ वकील कपिल सिब्बल ने चुनाव आयोग के फैसले को चुनौती देते हुए कोर्ट में ऐसी दलीलें दी जिससे पूरी बहस पलट गई। वरिष्ठ अधिवक्ता कपिल सिब्बल के वो मुख्य तर्क क्या थे और कोर्ट ने इस पर क्या तीखी टिप्पणी की, सब कुछ समझेंगे बहुत ही संक्षेप में। वीडियो को आखिर तक जरूर देखिए।
So both of us never went to the commission, Maharaj. Where did the commission get this from? The commission held that the same was not categorically taken on record, Maharaj. Where is it in the section 29A? Where is it that an amended constitution has to be taken on record? We, Maharaj, inform the commission of the amendments. See the Maharaj, see the no, but see, Maharaj, the unjustness of this kind of a analysis. The speaker doesn't decide the disqualification. The facts are clear. They are covered by a judgment of the court. They are covered by several judgments of the court. You don't decide it. The Election Commission disregards the organizational wing, decides on legislative majority, which should not have ever happened, that government should never have been formed because they were deemed to be disqualified. And then, Mullah, the whole process takes place, and then they get everything, the party, the symbol, and Mullah, these people in power are like a magnet, Mullah, as your Lordship knows. That magnet attracts a lot of disparate people, even disgruntled people or happy people, because they look for new prospects. So your 31 will become 39 and 39 will become 56. Lordship has that? However, as per the letter of 27/2/2018, by way of which details of the last organizational elections were communicated, names of 9 elected Shiv Sena leaders were mentioned and details of the other 4 positions in the Rashtriya Karkarni were not mentioned therein, which is completely wrong, Malaj. I'll show that to your Lordship on the record. 4 Shiv Sena leaders were appointed by the Shiv Sena Paksh Pramukh, who are required to be elected by the Pratinidhi Sabha during the next organizational elections to become members of the Rashtriya Karkarni, as mentioned in the party constitution. The credibility of the numerical count in the Rashtriya Karkarni is being eroded by the smallness of the counting universe being 13. It also is being denuded by an opaqueness in the description of its membership and it being situated in a non-democratic system. So where is the jurisdiction for the commission to do that? And the commission now refers to the 2018 constitution, which the commission discards. The Election Commission has erroneously refused to place reliance on the majority by the petitioner in the main electoral college of the party, namely Pratinidhi Sabha, on the ground that it is largely an appointed body. The Honorable Election Commission has disregarded the organizational wing of the Shiv Sena political party on the erroneous basis that the same is not in accordance with the 1999 party constitution and that the same is undemocratic. But where is the question of this in a para 15 dispute? It is respectfully submitted that the Election Commission had no jurisdiction in proceedings under para 15 of the symbols order to disregard the organizational leadership of the party, which had been duly notified to and taken on record by the Election Commission. Reliance is placed on the law laid down in Chotubai Amar Singh Wasawa versus Nitish Kumar, where the Election Commission held that organizational elections of a political party or the non-compliance with the party constitution cannot be agitated in proceedings under paragraph 15 of the symbols order. Similarly, in Arjun Singh versus President Indian National Congress, Election Commission held that in proceedings under 15, it is not open for a party to allege violation of the party constitution when both sides have acquiesced and acted in the same breath. So both of us never went to the commission, Maharaj. Where did the commission get this from? The Election Commission has failed to appreciate that the members of the Legislative Assembly are elected to the House on the ticket of the political party based on the prescribed form furnished to the returning officers by the authorized political leadership of the party, which is the symbols order.
The rest of the board is discharged. No other case will be taken.
Thus, the organizational wing of the political party is the basis on which a candidate is able to contest the election as a member of the political party. And even after election, his name is recorded along with the political party to which he belongs. To disregard the organizational wing is being based on an undemocratic constitution and instead rely upon the legislative wing, which owes its origin to the very organizational wing, is completely absurd and unlawful. Despite finding that both parties had relied on the 2018 constitution, and despite the same being duly supplied to the commission, the commission held that the same was not categorically taken on record. Malas, where is it in the section 29A? Where is it that an amended constitution has to be taken on record? We must inform the commission of the amendments. The only constitution that is taken on record is at the time of registration, because the guidelines to the commission say that you will have to, in that constitution, have a provision for amendment of the constitution. So, as and when we amend provisions, we inform the commission of what is amended. That's all. Though it is our case that we gave it along with the letter, but we can't now prove any of that. They deny it. But the fact of the matter is, where is that requirement? Moreover, the Election Commission erroneously held that the 2018 constitution was not democratic. Based on these untenable reasons, the Commission has based its entire decision-making process on the legislative majority employed by the respondent. See the but see, the unjustness of this kind of a analysis. The Speaker doesn't decide the disqualification. The facts are clear. They are covered by a judgment of the court. They are covered by several judgments of the court. You don't decide it. The Election Commission disregards the organizational wing, decides on legislative majority, which should not have ever happened. That government should never have been formed because they were deemed to be disqualified. And then the whole process takes place, and then they get everything, the party, the symbol, and these people in power are like a magnet, as your lordship knows. That magnet attracts a lot of disparate people, even disgruntled people or happy people, because they look for new prospects. So your 31 will become 39, and 39 will become 56. And if you let that happen, which is, I think it was, according to me, and we will in another case argue, this is a wrong procedure to adopt. To let the disqualification linger, hopefully in another case I'll argue that. So now 22 to 2023. At the time when the split took place, they had 20 members, 1 member of the Lok Sabha. We had 21 members of the Lok Sabha who were with us. 18 Lok Sabha and 3 Rajya Sabha who were with us. They all went away after he became Chief Minister. It will bound to happen. So it's this creeping majority that takes over because power attracts. Anyway, the petitioner filed SLP number so-and-so against the final order dated 17/2/23 and 20/2/23. Notice was issued to the SLP and interim directions were passed by the commission, by the court, continuing the name Shiv Sena, Uddhav Balasaheb Thackeray and the symbol, flaming torch allotted to the petitioner group by the interim order dated so-and-so passed by the commission. The Constitution bench of then we come to Subhash Desai's judgment. Kindly see, political party and the kindly look at Subhash Desai's judgment. You will find that at the compilation. What the original judgments volume was too thick, 400 odd. We don't need that. So we've sort of made a smaller volume for your lord. It's easier this way,
All the relevant ones are there.
Yes, all the relevant judgments. So if you look at political party and legislative party are distinguishable concepts. That's where the learned judges discuss this issue. And come to 109 then. Bottom of page 71, last paragraph. Political party and legislature party cannot be conflated. The contention of the respondents that political party and legislative party is inextricably intertwined is erroneous for the following reasons. So they reject that argument. Parliament in its constituent capacity was conscious of the necessity of not allowing anti-defection laws to stifle intra-party dissent and the freedom of expression of legislators. It was with this objective that the defenses of merger and split, which was later omitted, were introduced. The 10th schedule confers legitimacy to the actions of the legislatures, which would otherwise lead to disqualification if a substantial number of legislators, 2/3 in the case of a merger and 1/3 in the case of the erstwhile provision for a split, disagree with the political party. The 10th schedule recognized the independent exercise of the legislature party to the limited extent of presenting a defense to the actions of the legislators, which would otherwise have amounted to defection. Kindly see,
They are only relevant for the purpose of the defense.
because the whole purpose of both paragraph 3, which is now erstwhile, and 4 is as a defense. So if I seek disqualification, the defense can be in a situation of a split under paragraph 3 that I am 1/3. In paragraph 4, that I am merged. The political party has merged and 2/3 of the legislative party has agreed to the merger. As a defense. But you can't interpret it. I'm sorry. Section 29A of the Representation of People's Act requires an association of individuals calling itself a political party to be registered with the ECI. The party need not have returned candidates to the assembly to be registered as a political party. Under the symbols order, a political party receives recognition as a state party or a national party based on the total number of candidates returned to the assembly by the political party and or the total percentage of votes secured in the election. The purpose of the requirement under the symbols order is to identify whether the political party has a substantial presence in the electoral fray to freeze an electoral symbol for that party. The symbols order does not refer to an association of legislators, dehors the political parties. Like the 10th schedule, it recognizes a legislator and a political party. Thus, the reference to provisions of the symbols order to argue that the concepts of political party and legislative party are intertwined does not hold merit because the concept of legislative party is not recognized by the symbols order. This is very important. It's only the political party which is recognized.
The primary substratum political.
That's right.
From that springs the legislative.
Absolutely. And if you base your decision on the legislative party, then it's a problem.
Well, come to 161 and 162.
161.
I was indicating.
Yeah,
The two decisions operate on different planes.
yes, that's correct. They do, Malaj. But the facts, but they must be there for them to operate. I'm reading it with, I have marked it, Malaj. I myself marked it. I marked it in yellow here, Malaj, because I knew I will read it. I'll read that, Malaj. At this stage, a question may arise as to whether the decision of the ECI under the symbols order must be consistent with the decision of the speaker under the 10th schedule. The answer is no, and I agree. I agree, Malaj. The question is, what are the basis of that decision? Of course, they can be different.
That is the reasoning which weighed with the bench to allow the proceedings to proceed simultaneously.
But try it. But Malaj, see what? Of course, it can proceed. But nobody knew that they would not decide the disqualification. we must, Malaj, know the reality. Nobody knew.
Dragging of the feet.
Yes, yes. Reply in 23. And then deciding it on the basis of legislative majority. So what it makes Malaj. That's why ultimately Malaj, institutional integrity is the heart of democratic way of functioning. Absence of institutional integrity destroys the very foundations of democracy. This is the problem. Commission.
Eloquently quotes of institutional integrity.
It does, yes.
Quoting Dr. Ambedkar.
Ambedkar, then Kyoto Hollehorn repeats it. And they say this is a constitutional sin. That's what Kyoto says. Defection is a constitutional sin, Malad. Now it's a badge of honor, not a sin anymore. The decision.
We have 92 of the symbols of it.
Yes, yes, absolutely. Of the symbols of
Dr.
the.
Ambedkar saying that howsoever good a constitution may be, it is sure to turn out bad.
That's
because those who are called to work it happen to be a bad one.
In fact, we are relying upon it, sir. In fact,
And
we are
how
relying
about
What's the point of relying when the authorities don't? You may rely, but the authorities don't.
That's what is our case.
That's our case, Manas.
That's why I said the paragraph 92 actually voices your concern.
Sorry?
163 is what you are trying.
Yes, yes, I will just, yes. Then, Manas, the decision of ECI has prospective effect. Now, first of all, Manas, let's finish that. The answer is no. This is because the decision of the speaker and the decision of ECI are each based on different considerations. Correct. I have no dispute with that.
Ultimately, you also need to respond that originally your party constitution was completely based upon democratic principle. And then you suddenly brought an amendment and creating complete one man show.
We didn't, Manas. I'll show that to your lordship. I'll demonstrate that. But Manas, the question is, this is not the remit of the commission.
In it, when we talk of democratic principles in different institutions, governing the democratic values and the ideas, then question would arise that, well, as a political party, are you also not supposed to adapt to those principles?
I appreciate, Manas, the question is, there are institutions that perform a constitutional function. There are institutions that perform a political function. I think the level of, what should I say, integrity is much higher when you're performing a constitutional function. Whereas a political function can be rectified, but a decision made by a commission, seldom, in circumstances, can never be rectified. And this is what happens, for example, somebody could have said, you please change your constitution. We know of several cases where organizational elections are not held for years. Major political parties. Has anybody said it's done democratic and therefore I will take action and I will not recognize your constitution?
That is the line of reasonings on which the 2018 amended constitution is not relied by the election commission.
But that they can't do, Malas. How can they get into this in a paragraph 15 order?
Demonstrate that before us.
I'm sorry, Malas?
You demonstrate that proposition.
Yes, Malas. It says for.
Mind of the
No, Manas, I'm sorry, Manas. First of all, why do you say the 2018 constitution is undemocratic?